I'm going to turn it over very quickly to Kathryn Tucker, who's the lead attorney, and she'll give some opening remarks, walk you through some of the key points and issues that are happening now. Dr. Agarwal will join us later after he drops off his son at school. He's running a few minutes late. If you have questions, you can pose them in the chat box or raise your hand, and then we'll try to get to them. And we'll try to move quickly and cover everything we can that's new with this lawsuit. So Kathryn, take it away.
Hey, thanks so much, Brad. Really appreciate it. And good morning. Super early here on the West Coast, so still caffeinating. But I wanted to offer the opportunity for those in the media who are covering this really interesting, first of its kind case to hear about the robust amicus participation. It's pretty unusual in my experience to see this many amici come in, and some unusual amici. So I'll be spending my time talking about the amici. As you may know, a week ago, last Friday, the petitioners, who include a palliative care physician in the Seattle area, Dr. Sunil Agarwal, two of his patients with cancer, and his clinic, are the petitioners in this case, challenging the DEA's refusal to allow access to psilocybin therapy, for Dr. Agarwal to access psilocybin for therapeutic use with these patients with cancer, even though state and federal right to try law provide for that access. So petitioners' opening brief was filed a week ago last Friday, and I invite everyone to take a look at that, but also the amicus briefs, which were filed just this past Friday. All of those briefs can be accessed on the Emerge Law Group website. I am special counsel and co-chair of the psychedelic practice group at Emerge. So please find your way to the Emerge Law Group website. And I put up a short blog listing these amicus briefs embedded with links to each of the briefs. So all of this is there for you to take a look at. So I'm going to now turn to the 5 different amicus briefs that were filed, nearly all of them on behalf of multiple entities. So the first that I'll mention is the states. What the states came in to discuss with the court is their very special perspective on the respective role of state and federal government with regard to the regulation of the practice of medicine. That's what's at issue in this case. And so the states, and I will go through a list of who has come in as participating amici, are defending the autonomy and the sovereignty of the state to determine what constitutes legitimate medical practice within the borders of that state. This issue has come before the Supreme Court of the United States previously. There's very clear precedent that lodges authority over the regulation of the practice of medicine with the states. And so these states have come in to defend that. And that's an extremely foundational and important duty of the states to defend their right to regulate the practice of medicine and to defend duly enacted state legislation related to the practice of medicine, which is what right to try laws are. So the state of Washington is the lead amicus on this brief because this case is filed in the state or arose out of events that occurred in the state of Washington. And so the state of Washington in 2017 enacted its right to try statute by unanimous vote. Every single legislator in the state voted for the Washington Right to Try Act. So this state is stepping forward in defense of that statute, which permits seriously ill patients to access investigational drugs for therapeutic purposes. And the state is standing up and defending that. In addition to the state of Washington, Washington is joined by the state of Oregon, Oregon is the state that fought hard all the way to the Supreme Court of the United States to establish the principle that states are the primary regulators when it comes to the practice of medicine, and that an attempt by the DEA to nullify state law is outside the scope of the authority of the DEA and will not be permitted. That was the holding in Oregon et al. Versus Gonzalez, a Supreme Court decision from 2005. So Oregon has joined Washington on this amicus, as well as the states of Arizona, Delaware, Illinois, Michigan, Minnesota, Ohio, and the District of Columbia. So that in itself is quite a remarkable filing, and I invite you to access that on the Emerge Law Group website. When you visit that site, I have also given you, for each of these amicus briefs, a media contact person. So as you take interest in any or all of these amici briefs, you can find the point person who will take follow-on questions. That's the state's brief. Second amicus brief, in no particular order, is filed on behalf of the Cato Institute and the Goldwater Institute. These are both libertarian think tank advocacy organizations from the more conservative end of the political spectrum. The Goldwater Institute has been the primary sponsor and drafter of right to try laws, both the 41 state right to try laws and the federal enactment. That entity has a very particular specialized knowledge of the history of these enactments, what their intended reach and scope is, the underlying grassroots movement, the sweeping democratic movement that gave rise to these enactments, which swept the country in a firestorm between 2015 and today. 41 state enactments, many of them by unanimous vote, as well as a federal enactment. So those entities have come in defense of the libertarian principles that individuals, in consult with their physicians, should be empowered to make their own decisions about their medical care. Third amicus brief, again, no particular order, the ACLU of Washington. This is the state's leading advocacy organization for protection and defense of civil liberties, and speaks to the civil liberties implicated in the choice of patients with advanced illness to make their own informed decisions for their medical care. ACLU's brief, of course, speaks to how other important civil liberties in the medical care domain and in other personal decision-making domains create the precedent that requires the court to find in petitioner's favor. The fourth amicus brief has a very large coalition. I'm going to tick through the participants on this brief, all of them interesting in their own right. And some of them, if you've been following this work, will be familiar names to you, and quite remarkable to see them all on the same brief. End of Life Washington is an advocacy organization that's been functioning in the state of Washington really since 1990 with different names, but it is the state's leading organization that advocates on behalf of patients with terminal illness, that these patients be empowered with a wide range of choice so that they can have the kind of death that is most consistent with their values, preferences, and beliefs. In addition, the Washington State Psychological Association has joined that brief. It is the organization, the Professional Association of Mental Health Professionals who practice psychological counseling in the state of Washington. that entity very much aware of the mental health challenge faced by terminally ill patients, and very eager to see a promising new palliative care tool for mental health wellness in treatment of this population of patients. Next amicus on this brief, Evergreen Health. And by the way, when you pull up these individual briefs, each of the participating entities is described in the brief. So you'll have a fuller description of what each particular amicus does and is all about when you open the brief. Evergreen Health is a major hospital system in the state of Washington with hospice among the services that it provides. And it has come in to speak to the importance, again, of adding a palliative care tool to the toolbox. Next amici on this brief is a Sacred Passage Death Midwifery. Obviously, by the name, this is an organization that works directly one-on-one with patients who are addressing end-of-life issues and assist them and support them in doing so. Also on this brief are a number of really interesting individual signatories, including 2 past presidents of the American Academy of Hospice and Palliative Medicine, which is the nation's leading professional organization for clinicians practicing in that domain. Among them are 2 really interesting past presidents, Dr. Ira Byock and Dr. Timothy Quill. For those of you, unlike myself, who haven't practiced in the end-of-life care domain for 30 years, you may not grasp the significance of seeing Dr. Byock and Dr. Quill on the same brief. So I'll just share with you a little bit about that backstory. They're probably the 2 most highly respected end-of-life care specialist clinicians in the country. Both are widely published authors and prominent speakers at national educational events. Ira Byock has spent a lot of his career in opposition to the end-of-life choice known as death with dignity or aid in dying. And Dr. Timothy Quill has been a leading proponent of that choice. So the 2 of them have been bitterly divided on the question of whether dying patients should have the right to access medication to advance the time of death in the face of unbearable suffering. Those 2 clinicians come together on this brief to say, really, whatever you think about the choice of aid in dying, they are in agreement that dying patients should have the right to choose to have access to psilocybin therapy, a therapy which has been shown to elevate and expand consciousness and to change how the patient feels about their impending death. A really interesting pair on that brief. And of course, this brief does speak to the reality that Washington, as many states do, now permit patients the choice for aid in dying, where a patient is able to ask their palliative care clinician, their physician, for a prescription for controlled substances that will advance the time of death so that the patient can avoid further unwanted suffering. That choice is increasingly widely available across these United States. And against that backdrop, the question whether dying patients should have the right to psilocybin therapy, which could change the way they think about death, is a very important and interesting question. And Dr. Byock has published widely to express the view that this could change how patients think about the choice for aid in dying. And his hope is they would not want to access it if their existential issues have been addressed, which is the hope and the promise of psilocybin therapy. In addition, on this brief is the leading pioneering researcher in the field, Roland Griffiths at Johns Hopkins University. For those of you who are following the clinical trials about psilocybin therapy, and particularly in the context of patients with advanced illness, Dr. Griffiths has been the pioneering eminence in the field, with multiple studies coming out of Johns Hopkins reflecting that for patients with refractory anxiety and depression in terminal illness, a single session with psilocybin therapy eliminates that suffering, and no adverse clinical findings with regard to that treatment, and significant demonstrable efficacy findings even in the early studies. So Roland Griffiths has joined this brief to speak to the importance and the safety of making psilocybin therapy available to these patients, even though it remains in clinical trials. The findings are so strong in the early trials that access should be permitted now. And again, reflecting the reality that patients with advanced illness do not have the time to wait for the long, slow process of clinical trials to wend their way to completion. A number of other researchers have joined with Dr. Griffiths, including Matthew Johnson, who also has been on a number of the Johns Hopkins studies and may be familiar to you if you're following these studies. In addition, and again, to bring into focus the importance of what we're talking about here, which is the experience of a patient with advanced illness who finds themselves debilitated by anxiety and depression related to the reality that they are facing. A number of patients have joined this brief, different patients than who are on the petitioner's case, but to come forward and speak to their real life experience. And I want to share one of them with you. When you go to the brief that I'm speaking of, you will see that one of the declarants is a woman named Susan Patz. Susan, who lives in Washington State, 62 years old, married, mother of 2 children. She has ALS. ALS is a progressive motor neurological condition that inexorably eliminates the patient's ability to move their body. Bodily function and integrity decline over time, and there is no cure, and death is certain. This individual, Susan Patz, has come forward to talk about how ALS has impacted her life, the debilitating anxiety and depression that she bears every single day. Her husband, it so happens, is a palliative care specialist physician. Susan herself is a medical professional. She's a cardiac nurse. Obviously, she had to retire because of her illness. That's another feature of depression and anxiety for individuals who've had really meaningful careers. They're suddenly forced out of their career. She's lost the use of most of her ability to move her body, and she knows what lies ahead. So she is desperate for a palliative care option that can help her address that non-physical suffering. So I invite you to take a look at this brief, and I invite you to take a look at this patient's firsthand story. She is willing to speak to reporters who want to tell her story. And so feel free to be in touch with myself or Brad about having an interview with this patient. That brief that I've just described, the many who joined it, speak to the prevalence of depression and anxiety in patients with life-threatening illness, the devastating impact on both the quality of their life and very often the quantity. Evidence reflects that anxiety and depression in those with serious illness reduces treatment compliance and can also often shorten life expectancy. The promise of psilocybin as a tool is really exciting because over the last 25 years, the modalities of treatment to address physical pain and suffering have exploded. There are many new and efficacious therapies for physical pain and symptom management, but not so much with regard to non-physical suffering. And so this is an important tool to add to the palliative care toolbox for patients who don't have the time to wait for the clinical trials to complete their course. And then finally, the fifth of these many amicus briefs has been submitted by a cohort of the nation's leading health law professors and bioethicists who had a very specific purpose in their brief, and that was to speak to the criticisms that some have made of right to try laws, and discuss the reality that even if those criticisms are generally valid, they do not pertain in the context of psilocybin therapy for patients with advanced illness. So that's a really interesting discussion. And for anyone who has questions about whether right to try is a good policy, those answers are presented throughout that brief. So that's the fifth of these briefs. They're all really interesting. They all are submitted to the court as friends of the court to help the court see these interesting and unusual perspectives that these groups bring to bear. So I'm going to stop there and invite you again to take a look at all of them. Feel free to reach out to the point person if you'd like comment on each and any of them. And then also, I'm happy to take any questions. So come off of mute if you have a question, and I'll be very happy to see if I can answer them. And also, I believe Dr. Agarwal may have come on. I see his phone. So if you have a question either for myself as counsel.
Yes, I'm here.
Okay, beautiful. Or for Dr. Agarwal as the clinician, feel free to ask your question. Or type it in the chat if you're shy.
Hi, it's Diana Jones. I'll just ask a quick question. Maybe you can just say overall how so many different groups came together to weigh in on this issue. Does it really speak to the significance of the case?
Yes, I think it does. This is a first of its kind case. As I mentioned, right to try is relatively new. First state enactment effective 2015, and the state of Washington's enactment 2017, and the federal enactment 2018. So these are fairly recent enactments. There has been zero litigation that I'm aware of. There are no reported cases that relate to right to try. And yet it is a sweeping paradigm shift with regard to access to investigational drugs. The right to try is embedded in the Food, Drug, and Cosmetics Act. It is an amendment of the FDCA. The FDCA is governed, the agency that implements it is the FDA. The FDCA takes precedence, has primacy over the Controlled Substances Act, which is another federal enactment that vests the DEA with law enforcement authority to prevent diversion of controlled substances. The DEA's role here is limited by that statutory framework. And for the DEA to attempt to essentially nullify state enactment and federal enactment, where the statutory scheme is as described, is a huge overreach. And I think the size of that overreach is what caused so many entities to come forward. It's kind of a shocking overreach. Other questions, comments?
I have just a brief question, Kate. This is Nicholas Cozy. With not necessarily with respect to the right to try laws, but this concept that the states have the authority to regulate medical practice within their borders, and I see a potential conflict between that position and the FDA's role in regulating drugs and medical devices at the federal level. And so I'm thinking that, is there a situation where a state may deem a certain drug or medical device fit for medical use, but it hasn't been approved by the Food and Drug Administration, and how that potential conflict would be resolved?
Right. Well, that's such an interesting question and reflects an understanding of what is the proper role of the FDA. So the FDA does have an important function, and that is discussed in all of these briefs, including the petitioner's brief. But, the FDA's role of testing, overseeing the testing of investigational drugs so that they can become available drugs. That's its important role. This is why, the FDA oversees clinical trials that start with phase 1, which are generally about establishing safety, and moves on, if there's successful conclusion of phase 1, establishing safety, to phase 2 and phase 3 trials, which are more directed at determining efficacy. The understood reality of that framework is that it can take many, many, many years for a new drug to go from the beginning of that process to when it is approved for therapeutic use. Hence, the right to try is the democratically enacted permission embedded within the FDCA, which must be respected by the FDA, that in the unusual setting of an investigational drug that has cleared a phase 1 clinical trial, which is the case for psilocybin, and a drug that remains under investigation in later stage trials, which is also true for psilocybin, those investigational drugs will be deemed eligible investigational drugs for purposes of right to try. And in the context of therapeutic treatment of patients with life-threatening illness who do not have the time to wait for the long, slow process of new drug approval to conclude, that population is to be allowed access to eligible investigational drugs. So it is a special permission for a special set of drugs and a special population. Now, it is a large population. If you were to look at the data for how many patients die of terminal illness every year in the United States, that's going to be a large number. How many of those patients have refractory anxiety and depression? That's going to be that's going to be a fraction of that population, but it's still going to be a large number. For that population, they are, by the letter and the intent of right to try, they are to be able to access this drug for therapeutic use. And so I hope that answers your question. And I see Ben has one. So jump in, Ben.
Thanks. Yeah. Can you hear me okay?
Mm-hmm.
So I guess I just wanted to make sure I understand kind of the upshot of the state's brief, because it seems like they're saying, they stop short of saying basically, yes, we feel these patients qualify under state right to try laws, right? They say we take no position on that. But
Yeah,
some of
that's
the
a
language in
clinical.
there. some of the language in there sure seems like it's very encouraging. And I'm wondering, just to the degree that this is a lawsuit involving the DEA, is there any update on any sort of state level applications for access or anything else? Does this change or suggest anything on that front? Or are those things still kind of on hold as this is kind of processing?
Well, if I understand your question, I think there's two important things to keep in mind. The first is that the determination of whether a patient is an eligible patient or not, that's going to lie in the hands of the clinician. And so, the question is, each state has a statute of its own, each of the 41 states. Many of them are very similar. There are some variations that are worth noting, and we can talk about those. But they will use terms like a patient with life-threatening illness, a patient with serious or life-threatening illness, a patient with terminal illness. So those terms, slightly different, could encompass different populations of patients. It is the judgment of the medical professional as to whether their particular patient meets that criteria. With regard to whether a drug is an eligible investigational drug, the statutes, both state and federal, set out fairly clear criteria, and I've alluded to a number of them. Must have completed a phase 1 clinical trial. The drug must remain under investigation. So these are objective facts that can be checked against any particular investigational drug. If it meets that criteria, then one could conclude that it is in fact an eligible investigational drug. But absolutely fascinating is the fact that the FDA, which is the agency that implements the FDCA, in which the RTT is embedded, the FDA has put out 2 documents that bear on the questions that arise under RTT. One is a fact sheet, kind of a Q&A, and the other is a proposed rule. In those documents, the FDA disavows any authority over determining whether a particular drug is an eligible investigational drug, and it lodges authority for that determination with the manufacturer very clearly. That's a really interesting aspect of this scheme. But yeah, I think you're right, Ben, just to circle back. When you read the state's amicus, it's pretty clear that the states come out to say that, yes, certainly there is going to be a population of patients eligible, and that it appears that psilocybin meets the requirements to be deemed an eligible investigational drug. And interestingly, the state's brief goes further, and the states say, this is not the only drug. Psilocybin is not the only drug that could be at issue here, because those of us who follow what's happening in the psychedelic research world are aware that other drugs meet the requirements of eligible investigational drug. And the state calls out with specificity the research being done on MDMA.
All right, thank you. Does it, what relevance does the manufacturer criterion play there, given that, at least in some cases, it's not clear where you would have a legal source, I mean, correct me if I'm wrong, of psilocybin because of this CSA?
Right. Well, so no manufacturer is going to supply a clinician like Dr. Agarwal, who, obviously is a highly credentialed, licensed, registered with the DEA and with his state medical board. No one is going to supply even such a purchaser without some kind of green light from the DEA. And in this case, we did search out a willing supplier that is already a registered manufacturer and distributor. And we approached that entity on behalf of Dr. Agarwal and provided the patient's informed consent attached to his inquiry. And of course, what that supplier responded was it could not supply without some form of permission from the DEA, even though it was willing otherwise to do so. And hence our approach to DEA to seek out a form of permission. And no form of permission was forthcoming. So in the face of an absolute barrier to DEA permission, this lawsuit was filed.
Thank you.
Other questions? And yes, I see Sunil Agarwal is with us, so feel free to jump in.
Thank you, Kathryn. I got a question here from one of the folks in the room. They would like to hear about how the patients are doing and feeling about this effort, this movement. I wonder if you know, I'm certainly happy to speak, and if any of them are here want to speak too, they're more than welcome to speak. But it just from as their treating physician's perspective, I can tell you that, you know, Aaron and Mikal, who have come forth to do this, we were all very, very grateful that the court allowed for an expeditious review of this case. There's been already a tremendous amount of waiting, you know, with all the process that's been happening ever since the day we discussed this, and you know, in their clinical appointments, in our treatment plan. And so we were happy that this is going to be moving forward, and that the government did not contest that, because they are absolutely, time is of the essence. And then, you know, as far as how they're faring, you know, as good as they can, given the circumstances. I think this is they're in this. Both of them are at different points in their in what's going on with their health and their health conditions. Both are struggling with different types of cancer diagnoses, both advanced at different stages with different histories. And I think it's they're doing all their medical appointments, trying to do everything they can, trying to live as best as they can in the face of what's been going on in the community and COVID and everything else. It's very difficult. And, you know, definitely they struggle with issues related to anxiety and depression, or you can say demoralization or hopelessness, a sense of, yeah, you know, like being really just challenged. But this case certainly gives them some hope that they can get some additional help with that. And I think that this has really helped them, you know, and it's always a challenge putting all your health factors in the limelight like this. But I really, I have tremendous gratitude for them to do this on behalf of themselves and the class of patients that they represent. They are acutely aware of that, and I really appreciate all the media folks for respecting their privacy when they request it, and you know, approaching them respectfully to talk about this. And I'm always available to answer any of your questions on their behalf as well. So that's about as good as I could say that they're doing right now, and I hope that helps.
Yeah, no, I appreciate that. And, you know, in these cases, my work has been in the domain of protecting and expanding the rights of patients with terminal illness for 30 years. And anytime one of these cases goes forward, we always need individual patients who are facing the issue that the case raises to come forward. And it's always a huge burden on them. People with advanced illness, probably no one ever likes being part of a lawsuit, but when you have advanced illness and you're burdened with all that entails, to also come forward and be part of a lawsuit and disclose your identity publicly It's a tremendous contribution to the public good, and we're really grateful when individuals are willing to make that sacrifice and commitment. And often, you know, I've been in these similar cases around the issues of death with dignity, where the patients didn't survive the litigation because lawsuits move slowly. So sometimes they're making a contribution that they won't actually be the beneficiary of. We hope that's not going to be the case here. Our hope is that the Ninth Circuit, which has put this on a fast track, is going to hear argument possibly as soon as September. And that was the first sitting at which there was the briefing would be concluded, because after these briefs, there's a round of briefing for the DOJ, the United States Department of Justice, will file a brief in defense of the DEA. And then the petitioners will have an opportunity to reply. All of that briefing will conclude in August. And the first sitting of the Ninth Circuit panels available is September. And I believe we may be set on a September calendar. Those are all live streamed now, so anyone that's interested will be able to watch that argument. But our hope is that the court will give a very clear indication to DOJ and DEA through a vacate and remand that the DEA must respect the letter and intent of right to try, which is the law of the land and the law of 41 states, and create a user-friendly avenue for clinicians like Dr. Agarwal to obtain psilocybin for therapeutic use with patients with life-threatening illness. That is our hope, that is our goal, and that's where our attention is focused. So any final questions? Or we are grateful for your attendance, and we'll look forward to working with you on getting the word out about this important case, which has really far-reaching ramifications for a lot of reasons. All right, thank you all. To be continued. Thanks, Brad, for convening. All right.
Have a great
Take
day,
care.
everybody.
Yeah.
Bye-bye.
Thank you. Bye.